Hello friends, welcome back to Pen and Paper YouTube channel. Here we simplify complex legal topics using just a pen and paper. So today we are exposing the myths around check bounce law in India. So basically we are going to discuss the misconceptions that often lead to conviction. So this video is not meant to create panic among accused persons, but to expose a deeper problem: how some greedy advocates, basically the defense advocates, misguide their clients with false promises, leaving the accused to suffer alone at the end. So now we will look into these myths. So the first myth we are going to expose is, this is for the accused. So if he is going to say in the court that the check was blank, then he is going to be safe. So if in case accused, if he is just going to claim that the check was blank, this is not going to, that is, protect him anyway. If in case if it is signed, so basically a signed check is basically is a presumption of liability in the eyes of law. If in case if a complainantee has provided the signed check and later it is going to be dishonor, or it is the payment is going to be stopped, then there is a presumption under law that there is a legally you owed some debt for which you have given the check to the complainant. So definitely, if in case the burden is going to shift on the drawer to prove that it has been misused, that he has just signed, but the complainant has given produced to the bank and later it got bounced. And also, unless if you are going to file a complaint, so basically there is a check which you have given for any reason, or the check has been stolen, and the blank check was uh, basically it was got stolen, and you were not aware of the process what has happened later. So until and unless you are going to show to the court that you have filed a proper complaint, if there is no complaint that to show or the misuse of the check, then the defense is going to be fail. So just mere mentioning that check was blank and later it was produced, it is not going to save you. So this is the myth one what we have discussed. And if in case if we try to see this with an example, so there is Mr. A who said the check was blank, or he hasn't signed the check, so it was misused. So during the later progress of the trial in the court, when questioned, so there was no FIR file for the stolen or the blank check. This is very, very important. And the court is going to see this as the afterthought. So after giving the check to the complainant, the thought has arisen in the accused mind, and then it is going to be convicted under section 138 of the Negotiable Instrument Act. So very simple. So if in case any accused, if you are an accused and if you are watching this video and if you have a myth that mere mentioning that the check was blank and it was misused is not going to save you in the court. So now we will see the second myth, that is there is no written debt or the loan agreement, so I can simply deny the debt that it is not existing. So under myth 2, so basically some accused are going to believe that without a written agreement, so they can deny the liability. So again, friends, under section 138, whenever there is a trial which is going on in the court, so written agreement is not at all mandatory to prove from the complainant, because the check itself is going to be the solid evidence here that there was some liability which is existing to which you have given the check. So again, the court is also going to consider if in case there is no written agreement between accused and the complainant, so the court also going to consider the evidence if there is any WhatsApp chat or there is any transfer or any of the bank transfer. So all these things are going to matter here, and not just mere mentioning that there is no written loan or the agreement between accused and the complainant. So now we will try to see with an example. So there is a person, Mr. B. So what he does is he proved the loan through chats that bank transfer has also been happened with A. So he is Mr. A. So in return he has paid the check. So here is denial that there is like there is no agreement between us because B has already provided the chats, transfers, or any kind of witness who were present at the time. So A's denial is going to fail here, and the check bounce conviction is going to stand in favor of Mr. B, who is the complainant. So moving ahead, we will also try to see the next myth we have. That is, I can just deny everything in court. So I can just say there is, I don't know the complainant. I don't know how the check came to him. And I also don't know there is any transaction between both of us. Okay, so just mere denial for everything in court. So let's see that aspect. So we have also seen there some accused who are advised by their advocates to deny everything, which is also called as blanket denial, but the contradictions and lack of evidence, which is going to destroy the credibility. Very important. So during the initial stage of the trial, so when the accused is being brought to the court, so when judge is asking all the questions relating to the check bounce which has happened, so at that time the accused tend to deny everything, and it is going to hurt the credibility. And the court is also going to expect a consistent and the supported defense, not just mentioning the blanket denial that this is not, we don't know how this check came, the signature is not mine, we don't know the complainant, there is no transaction between us. So these kind of blanket denials are not going to support your case, which are which will definitely going against the accused in the court. So now let's understand with an example. So there is Mr. C who denied the loan what he has taken, and then he admitted the signing of the check. So first he denied the loan, there was existing loan. Then he later admitted at some point when the complainant advocate crossed examined him. So at that point he confirmed and admitted that the check was signed by him and given to the complainant. So now in this scenario, his own words trapped him in the court, and the judge called his defense, that is unreliable and evasive. So likewise, his defense is not going to stand, and which trapped him in his own words. So if you are an accused and if you have been advised just to deny everything, so this is not going to help you in the court. This will go against you. So now we will be looking into the next myth, that is check bounce is a civil matter and it is not a criminal matter. So most of the accused are being advised by their advocates just to misguide them that this is a just a civil matter, not a criminal matter. So nothing to worry about that. So let's look into this. So while looking at section 138 of the Negotiable Instrument Act, so the check bounce or the check dishonor is going to be a criminal offense. It is not a civil offense here, but there is also civil recovery which is going to follow up. And The thing is that you are going to be punishable with jail if it is proved that check was given for a legally debt, and fine. Fine is also going to include the principal amount of the check. So basically the accused is going to face the jail plus the fine including the principal amount of the check. And also there is going to follow the civil recovery, which is also going to follow this separate along with the all the that is the punishment and the fine. So uh, you need to also make sure that this is going to be a criminal record that so and so person has done this offense, and due to which he is going to be he has been punished. So now we will try to look into this with an example. So there is Mr. D. So what he did, he just ignored the legal notice what he has received for some of the legally enforceable debt, and he thought that this is going to be a civil matter. We can just extend this up to n number of years, and then he started missing the court dates. He arrived at some point, and later again he started to just be absent in the court. And later what happened? The matter went all the process steps in the uh, section 138, and he was convicted in the absentia. That is, even though the accused is not present in the court during the trials, so later at a point the court thought that yes, there was a legally enforceable debt and he was convicted in his absence. So this is a very big confusion which the accused are going to have in the check bounce matter. So the next thing we are going to see, that is the myth, is I will win if I just keep on delaying the case. So there are scenarios where some of the accused are going to try the delay proceedings. So basically this is the defense advocate's tactic just to drag the case, and just to make sure that the complainant will give up at one day. And now the courts, what they are doing is they are just moving the fast track check bounce cases. That is a speedy trial, and this delay is also going to close off the defense if in case there is no defense evidence is being provided by the accused and his advocate, and it is going to lead to the direct conviction. So the delay tactics is not at all going to help the accused, uh, hoping that the complainant will give up at some point of time, and they will see the defense advocate is also going to keep on telling that nothing to worry, we are going to win, and he is going to give up the case. So we will try to understand this scenario with one more example. So there is a person, Mr. E. So what he is doing is he keep on seeking adjournments in the court. So for each and every date, whenever he is coming, he is asking, seeking some more time to produce the defense evidence or something like that. So the court is going to struck off his defense. So they will say the defense has not provided um, the defense evidence, and they are going to struck off his defense, and they are going to convict him based on the complainant's evidence alone. So this is a very, very um, big mistake which the accused are going to. They either they are not going to pay, or not they are going to mention that they will be able to pay, give us some time, or they have this much of amount and later we are going to pay this much. No, there is nothing they are going to talk about the payment. They keep on seeking the adjournments, and the court is also going to struck off the defense evidence, and they will convict the accused based on the complainant evidence alone. So now we will see how misconceptions are going to lead to conviction. So the myths what we have discussed till now, these are just not harmless. They are also going to lead to the real convictions, which has already been happened with many of the accused. So basically, if in case there is any false, that is the tactics and the poor defense or the advice which has been received from the advocate, and there is also going to be a lack of evidence which is going to trap the owner, that is the drawer of the check who has given. So this is also a wrong strategy and loss of credibility in the case. And the uh, whenever the accused is being served with the notice or the summons, they are going to miss that opportunity, and they will also end up in the court stating that they will be paying and they want to pay and they want to close the case along with the expenses whatever has been incurred by the complainant, and the law is going to reward honestly to the complainant and preparation, not denial and delay. So if in case there is no evidence from the defense side, there is also no escape from the law, what the law is going to clearly state under section 138. So now we will look into some key takeaways from this video. So the first key takeaway we are going to discuss is you need to understand section 138 properly. So there should not be any confusion in understanding this law, because most of the accused end up just misguiding by their advocates. So you should not rely on just myths. This might not happen, or this is going to happen, or hearsay. If some person is going to say that there are many check bounces which are going to happen and you do not need to worry. So these are all kind of myths or the hearsay you should not rely on. And if in case if your check has been really misused, then you need to file the complaint immediately. So that is going to save you in the court. And you need to also preserve chats, bank records, any kind of statement which is going to support your case in the court. And you need to choose the legal strategy based on facts or the documentary evidence, not just mere mentioning orally. This is not going to support you. So check bounce is a this law is very powerful, but it is also going to fair towards the complainant as well as to the accused. So you need to know your rights, you need to preserve your evidence, and you need to avoid falling for any kind of myths. And a smart strategy is going to begin with the truth, which is going to prevail. And we will now see who is going to suffer. So this is very important. So that we are going to see now. So now we need to be clear. The sufferer is the accused and not his advocate. That is the defense advocate. So the false presumption that any defense is good defense is finally which is going to break in this section 138, that is the check bounce cases, and many accused are going to looted financially and emotionally by defense advocates who sell fake promises and hollow strategies. So this is very important. So make sure that whenever you are taking any advice or you are any appointing your defense advocate, so see what he is really promising to you, what the real fact he is telling to you. You need to also cross check the same scenario what your advocate, maybe you are knowing him from many years or generations, but you need to also cross check what now he is going to sell, which is the fake promise in this matter. So at the end, what is going to happen? At the end, the time of the accused, the money of the accused, and dignity of the accused is going to lost at the end, and the final sufferer is the accused, not his advocate. So this video, the intention of making this video is not to scare you, but to expose the truth. So you deserve better advocate or better lawyer, or early settlement, or convincing the judge that I am ready to pay. So kindly convince the complainant that I am able to pay this much of amount now, later at this point of time. Allow me some time frame. I am ready to pay, just not blindly keep on adjourning or telling that everything is fake and everything is going to work in my favor. So this was the pen and paper channel. Here we simplify law with just pen and paper. If this myth has been the myth busting episode which has helped you, that if someone who is going to need of this information, you can just share with them. If you really like the video, and you need to subscribe the channel for more such exposing information. So let's build a legal community that is informed, empowered, and no longer misguided. Thank you.